so we can hear you.
Not hearing anybody indicate that they can hear me. Can somebody give me a thumbs up if they can hear?
We can hear.
Are you able to hear us, Professor? We can hear you.
Robin, can you hear me?
Yes, I can hear you. We can't, you obviously can't hear us. Professor Francis is going to disconnect and reconnect in.
Okay, let's try now. Can folks hear me? Okay, good.
We can hear you, Professor.
All right, thank you very much. All right, I have gotten feedback from 2 of you on the draft that we circulated. So I got comments from Spence yesterday and from Hope through Secretary Zamuda this morning. And so actually just a couple of minutes before the meeting. So we're going to go through both of those just for purposes of record keeping or whatever. This is the meeting of the Dual Supervision Subcommittee, which is part of the Criminal Justice Reform Commission. My name is John Francis. I am the chair of this subcommittee. I see in this group Secretary Zamuda, Sheriff Carr, Spence Cohen, Hope Cooper, and Lindsay Archer, and I saw Senator Haley just a moment ago. I see him now. Okay, and I think that is everyone. So besides the folks who have had a chance to send me written comments, has anybody else been working on edits or comments along the way that we can kind of talk about as well?
This is Sheriff Carr. I have not had a chance to review it. I'm currently reading it at a task with a bunch of other stuff currently. My apologies.
No, no need to apologize. I absolutely understand, so no worries at all. What I'm going to suggest is, so editing a document with multiple feedback is a little bit tricky, but I'm going to suggest that we go through Hope Cooper's first. And just, I haven't even reviewed all of it. I just took a quick scan of what she sent a few moments ago, but let me go ahead and share screen with or from Hope's, and I think that's going to be this one right here. And you all see this Word document, which in the side has a comment from Hope. Everybody see that?
Can you expand that out? We see 2 screens.
Okay. Let me see what I can do here. I'm going to stop sharing for a moment and do that again. because I have multiple Word documents that are open. Let's try. Let me first maximize that one. Okay, so that's maximized and should be this one. How about now?
Yep.
Okay, good. Thank you. All right. So I think what we'll do is, as we go through and see things that we like from the changes, we'll go ahead and adopt those. I want to go through hopes, and then we'll go through Spence's, and what I'll wind up doing probably along the way is cutting and pasting Spence comments into this one. Introduction is pretty straightforward. I've put Monday's date on there because I assume that's the date that we're supposed to submit it to the commission. First paragraph is really just what we've been doing, the dates we've met, and that frankly we've leaned on CSG a lot in gathering of information. The problem statement that's here, really I just cut and pasted from the memo that CSG sent to us. Hope suggests using the word "it is estimated," and I think she's right. I think that's a good change to make. So I'm going to go ahead and do that. So it's estimated that 5 to 10% of the supervision population are on supervision. And then down here, results in lack of coordination, duplication assessment, or multiple drug and alcohol testing. Yeah, I like that too. So let me go ahead and accept that change. Can have a cascading effect. I agree with that also. And then our goal. So one of the things that I struggled with was, are we calling these entities agencies? And I realized that in my draft, I was all over the board with that. And I similarly struggled with, do we want to call people under supervision, supervisees, defendants, clients, whatever it is. I think we need to use consistent language. I don't have a strong feeling, but I do want to hear what people's thoughts are. Should we be referring to these as supervision entities? Should we be referring to them as agencies? What are your thoughts?
I will just tell you from my standpoint, and Spence, you can certainly have a different opinion on this. I call them supervision entities just because we have different branches. We have different, like they could be judicial districts. We're an agency, Department of Corrections, and certainly community corrections, you could call them agencies, but they're not one agency. And so I call them supervision entities. And then I also call them people under a person under supervision, because it's a mouthful to say probation or parolee, and then there's confusing. What paragraph are you talking about? So I just call them person under supervision.
Yeah, and I like the person under supervision part that you're talking about, because initially I was thinking, well, we'll refer to somebody as a probationer, but that would not capture someone who's on parole. And so that was a little bit awkward. And then I was kind of in this middle ground of calling them supervisees. And then we're talking about supervisor and under supervision and supervisees. And it was, some of those sentences in there are a mess. And that's on me. So are folks in agreement with using the nomenclature entities rather than agencies? Okay, I only have a small.
Spence Cohen, and I hate to agree with you, but I think it does make sense. And as you'll see as you go through my edits as well, that and I actually I'm reading my edit and I didn't even stick with what I'm saying, but Above, we have multiple supervisors, and I changed that to probation officers. And then as you list supervision agent, I changed that to supervision officer. So I like the term keeping them as supervision officers throughout the document. And you'll see, I think I also changed supervisee. I just changed it all to probationer. But again, that was just my own thinking when I read it. That's what makes sense to me. So.
Yeah, so at one point, when I was initially drafting, I was thinking it would be a little cleaner if we could say probationer, but I don't think that captures people on parole. I mean, we know it does, but I'm concerned about, a third party reader. And that's why I was in this, awkward place of supervisee. I think maybe where possible, and it may not be always grammatically possible, to say person under supervision, and we might use supervisee and person under supervision interchangeably depending on just the grammar of a particular sentence, if that's okay with everyone.
I like that. I would even add, because sometimes I thought, okay, you could put probationer / parolee, but a parolee doesn't even include everyone we supervise, which is post-release supervision, which is completely different than parole. So then I keep going back to person under supervision.
Okay. All right. So let's stick with that, because I am concerned that a term might get put into legislation and that it might not include somebody who it's intended to include. And even as somebody who's worked in the system, I don't think, I would have appreciated the difference between somebody who's not a parolee and not a probationer, but they're under supervision. And so, yeah, I think person under supervision or supervisee will be better. So here, I think we can say this proposal is intended to improve outcomes for persons under supervision. We can just go ahead and deal with that here, and communities, with the expectation that by reducing duplication of services and expenditure of resources, there will also be a budgetary benefit. Let me just zoom that a little. Okay, then sorry to bounce around a little bit. So the recommendation was something that I did not take from the report. I kind of distilled that from our notes. In a way, it's duplicative of the goal, but I think we want to be specific about the fact that that we do have a recommendation. Shelley, you had a chat that popped up, but it didn't stay on my screen. Do you want to just pipe in with that?
She's asking for a copy. I'll send it to her.
Oh, okay. All right. And let's see. Okay, so recommendation: subcommittee recommends that procedures be adopted so that persons under dual or multiple supervision report to only one supervising agent. So as a starting point, are we in agreement on that that's a recommendation? Okay, hearing no objections to that. And Spence, as we're going through, I'm gonna try to follow along on my screen what you had, but you could also.
Hey, real quick, the Sheriff Carr.
Yeah.
So just, yeah, I guess more of a discussion point here. Do we want to clarify the exceptions to municipal court cases, just so people understand that that's not part of this, for clarity?
Yes. Yeah. And I'm not there yet. That's like about a half page down.
I'm just wondering if it wouldn't be better suited up in here where you're starting the discussion and have, with the exception of municipal supervision.
Okay. Well, so I think we're still recommending that people under municipal court supervision just be supervised by one person. I think, at least my thought on that was that we're not rolling that in, because that just includes a layer of legislative complexity. And I'm not even sure about the issues of, are there home rule issues that prevent state legislation from doing that. And so one of the things that Chairman Bennett had recommended at our last big commission meeting was, include language that says municipal courts may enter into voluntary agreements or something like that. And so I think there may be value in discussing that as an option. And so I think it's still aspirational that, one of our goals is that the persons under dual or multiple supervision report to only one supervising agency or agent. I think, if this legislation is adopted, it would become mandatory for state level agencies and recommended for municipal agencies. And so I agree with you that we do want to address that, but just in the really broad brushstrokes in this first recommendation, I'd rather save that. I'd rather hit the kind of the top level issues and then get down into the municipal court issue where we have it about a half page later.
I'll just pipe in because you'll see under my recommendation or my edits, John, that I definitely did not agree that that's where our committee went. I don't remember that, and I thought we decided not to include municipal courts. Right. I don't mind though having it listed because that is an issue, but I don't think that that's where this. I thought we decided to leave municipal courts totally out of the recommendation, and I can again reiterate why there are issues with that. But that I know that that's on my edits later down.
And I did see that on your edits, and we'll talk about that in a minute. And it's good to know that we're not all, we all didn't have the same takeaway. Okay, so again, recommendation will be that agency would oversee applicable terms of all cases for which the person under supervision is being supervised. For this to occur, standards need to be established to determine which supervising entity will supervise the individual, address issues surrounding jurisdiction, enforcement of sentence provisions, and collection of fees. In addition, standards should be established to improve communication between agencies and to facilitate a ready means of sharing information about people under supervision. So are we in agreement on these recommendations, just as an outset? These are very broad brushstrokes. We're going to get deeper into them, but is everybody on this subcommittee agreeing that this reflects, that what's in this paragraph under recommendations reflects what we discussed and agreed to?
Professor Francis, I would just add in that last sentence, there's an agency that needs to be changed to entity.
Thank you. Between entities, thank you. Okay. Then Hope had some recommendations here, and I like these changes. So all three supervising agencies, and so let's go ahead and accept that, are community corrections, county level probation, which described as county level probation with state oversight and funding. I like that because I think that helps crystallize the differences here. I think if we can clarify the different, umbrellas that each of these is under, I think that will help. And parole.
Do we want to say county level probation with state oversight and funding? I do like that. Should it say by Department of Corrections? So just because I don't want people that are not familiar with the system like we are to think that state oversight would mean like OJA. I think it'd be good to clarify those two points.
I think that's a good point.
But I like that wording by Hope.
Yeah. So
again, sorry, I like it, but I do.
State oversight and funding by Department of
And so I might go purchase a lottery ticket. There's 2 times today that you have agreed with me.
This is your lucky day. Okay, and then since we're handling these, since we're just describing community corrections and parole separately, we get rid of the word both. Court services under OJA. Given the different entities, supervision philosophy and policy are different among all 3 agencies. Given different entities, supervision philosophy and policy are different among them. Okay, yeah. In addition, the court has jurisdiction over those persons supervised by the 2 entities, community correction and court services. And let's close in there. And the other, parole, is under authority of the Secretary of Corrections and jurisdiction of Prisoner Review Board. I think that's really clear. It helps a lot. And so if everybody's on board with that, I think we accept that change.
I would note that I did miss at the very beginning, the 3 supervising agencies should be entities.
Okay. Yep. I will do a search and replace when I go through this later. Let me just make a note for myself to do search and replace. Yes.
Maybe it's just me, but my readers aren't powerful enough. Could you blow up your screen just a little bit?
Yeah. No,
Okay,
that's fine. I'm usually the person who has that trouble, so no worries. Is that better?
Trying out my new glasses. Thank you.
Okay. We get that. And then we can get rid of. So I had wondered if here we should describe the different services, but I don't think we necessarily need to get into the weeds on that. And maybe not even in the report, just the fact that I think that that sentence that Hope added does say, you know, there's different supervision philosophies. Do we want to say different entity, given the different entity supervision philosophy and policy are different? Should we also add something that maybe even services, there are some differences in services offered by the different entities as well? And is that an accurate statement? I mean, that based on what we've been saying, it's my understanding that it is, but.
That is something we discussed in detail, or the program offerings from each one. So I would clarify that a little more.
What if we just said supervision philosophy, comma, policy and resources?
Supervision philosophy, comma. I like resources, but I also like what Sheriff Carr just said, which is program offerings, maybe program offerings and resources.
Okay.
And I apologize, I'm a poor typist. Okay, so given different entity supervision philosophy policies, policies, program offerings, and resources are different among all 3 entities. Okay. In addition, the court has jurisdiction over those persons supervised by 2 entities, community corrections, court services, and the other, parole, is under authority of Secretary of Corrections. Okay, I think that covers what I had wanted to get there. So get rid of that. Okay, dual or multiple supervision can occur under several circumstances with several combinations of courts and agencies. A person may be under supervision from a municipal court and a district court. And Sheriff Carr, this is where we start talking about municipal court. A person may be under supervision from district courts located in different districts. or a person may be under supervision for multiple cases within a single district, to identify a few. I'm sure there are more, but I thought that those are like the three really big ones. Either, courts from neighboring districts, or different cases within a single district, and we also have the muni and district court part. For example, if someone was sentenced in one case to supervision by court services and in another case supervision by community corrections, the plan would be to have just one of the entities actively supervise we don't want to use client, I think. Person under supervision. Oops, whoa. I hate it when it does that. Okay. So is everybody okay with that paragraph?
This is Sheriff Carr. I've
Yeah.
got one question or suggestion on the second sentence there.
Yep.
You have under supervision from district courts located in different districts.
Mm-hmm.
Anybody, I guess, object to adding different judicial districts?
I think that's good.
'Cause with that, I just feel we're tying more because we've got some judicial input or terminology.
Yeah, and what you're saying is more accurate. I mean, they are judicial districts. I was gonna say counties, but I was like, some counties overlap, but in the same district. But your addition makes that clearer and more correct.
And when you do a find and replace, there's some agencies in that paragraph that would need to be replaced.
Okay. I will do that later. Okay, to implement a plan in which people under multiple supervision will be supervised by one entity. Guidelines must be established to determine which entity should supervise an individual. And considerations to determine which entity supervise a person under dual or multiple supervision. Okay, so now we're starting to get a little more. So we've got the broad brushstrokes to start with. Now we're getting a little more detailed. Here's the part where we're talking about municipal courts, and so Spence had indicated in his draft that he didn't agree that we had, in fact, suggested that there be. His position was that we had decided not to address it, and I think at the subcommittee level, that is true. I think we had talked about, there's still the freedom for municipal courts to go ahead and on their own voluntarily engage in, develop MOUs with district courts. And Mark Bennett at the last commission meeting had suggested language like that. I actually thought that was a pretty good idea, so I included it. But if folks don't think that is a good idea to include that, let's talk about that now. Should we take out the language that says the subcommittee instead, and that would be right here. Subcommittee instead recommends that legislation include language that permits a municipal court to enter into a memorandum of understanding with state level entities to permit supervision of municipal court sentences by state entities in instances of multiple supervision. This arrangement should presently be permissible through permissive cooperation agreements. I'll get rid of the double. I would say should presently be possible through permissive cooperative agreements, but including this language in legislation would highlight this is an option and would not exclude municipal courts from concurrent supervision remedies. So what do folks think? Do we want to leave municipal courts out? Because we really didn't study that much. We initially said this, may create a legislative mess. Let's not worry about it. I was kind of picking up on Chairman Bennett's suggestion, which is, this might avoid the legislative mess by just making it clear that it's permissive to do it, and its exclusion is not necessarily intended to be something that would omit or prevent dual supervision. So what are folks' thoughts on that?
Let's Carr, my thoughts to scratch it all together.
Okay.
And stick strictly with the state level agenda. This just, I mean, we don't have Kansas League municipalities at the table. I mean, we're just lacking a lot of pieces to this, or stakeholders. And I don't know if we want to add something else for further discussion right now. And I think given, and Shelley, Hope, Spence, Secretary Zamuda, let me know if I'm out of order here, but even at my level, I mean, with what we do, we have minimal dealings with municipal courts and any other stuff other than the arrest warrants we have. So I just don't think we want to dive into these bushes right now.
Could we at least mention at the bottom, if I haven't seen the report yet, but if we're talking about continued work or ongoing continued work, I don't know. With us being a college and university town, we do have a lot of things that are diverted to the city. And so lots of our people are on with municipal court. And I'm just wondering if we, just make a statement that it's something, that should be looked into or considered in the future, because it does speak to what we're talking about with, probationers being on multiple supervision entities.
So if I could jump in on that, and Shelley, I agree with you. So here in Shawnee County and in Topeka, we do, and I've had a lot of clients who've been on municipal court supervision and district court supervision at the same time. And, as a general matter, municipal court supervision would kind of take a back seat on their own, but that I think was because of the people who were running it at the time. And so I like the idea of, identifying, look, we're not going to tackle that, but that might be something for the legislature to look at with input from municipal stakeholders. People want to use that type of language?
I think that's good, and that connects it to what we just discussed above, where we added municipal court as an option for dual supervision. So
so let's try and capture the language that we just said. Okay, these challenges, there are challenges to creating legislation that will uniformly govern municipal courts throughout the state. This may be an area for the legislature to explore in the future with input from proper municipal stakeholders. Does that language sound okay?
Well, and I'm wondering too, Professor Francis, this is Shelley, if Mr. Secretary or Hope has, isn't there maybe going to be implemented like an ongoing implementation team or committee of some sorts in the future?
Yeah, Shelley, I think there's going to have to be some kind of an oversight or implementation team for the oversight of the criminal justice reform after the work is done. I don't know exactly what that looks like. I think CSG will have some conversations with us give us some suggestions for that.
So maybe we just include, if there is an implementation team, that be something, in combination with the legislature.
Yeah, I think that's a good idea.
Okay, so it's maybe an area for the legislature, or I'll just put in parenthetically, or follow up, or implementation team following up criminal justice reform, or following up supervision reform. Okay, so this may be an area for the legislature or parenthetically, implementation team following up on supervision reform to explore in the future with input from proper municipal stakeholders. Everybody good with that?
I think you should add, instead of municipal stakeholders, with all stakeholders involved, because it's going to be a larger than just municipal. I mean, you're looking at state courts as well as DOC.
Okay.
And I would hate for them just to look into municipal courts, because municipal courts are going to jump all over this, and they're going to see it as a way to save money.
Sure.
And that's one of the big issues that I see.
From all stakeholders, including municipalities?
Yes. Yeah.
Okay. Thanks. I think that's a good clarification. Okay, now we're getting more into the direct part that we talked about. Concurrent district court sentences. A challenge in any dual or multiple supervision situation is to match a person under supervision with services and supervising entity services and the supervising entity that is best tailored to the needs and rehabilitation of.
Can you say that's best tailored to address the needs and rehabilitation of this?
It is best tailored to address, yes. The needs and rehabilitation of the person under supervision. Let me say, to address this, the subcommittee, since we just say we say address in the sentence before, we'll just say, as such, subcommittee suggests that the case involving the longest possible sentence should control which entity will supervise the sentences. And is that a correct statement of what we want? Okay, hearing nobody say no.
Do we need to, just a question, do we need to clarify longest probation period versus jail sentence, or is longest possible sentence clear enough?
Yeah, so I think that's a good question. We talked about the longest supervision sentence or the longest underlying sentence. And actually, I'm not
my
clear on that.
recollection was the longest underlying jail sentence, but
that was kind of my thought too.
I mean, I don't know if it needs clarified or not. Just my reading and thinking.
I think you're right. I think the longest underlying incarceratory sentence. Would that be correct?
That's what I thought we were talking about.
Okay. Okay, clearly didn't spell that right. No, they just don't like the word incarceratory. Yeah, oh well.
Incarceration?
No, I think it's a real word. It just Microsoft doesn't like it, that's all.
Well, it is Bill Gates' world, man. I mean, don't we have to conform to that, don't we?
Right. Longest incarceratory sentence should control which entity will supervise the sentences. The longest sentence, or most. And so here was something, I tossed this in and I should have highlighted it or put it in brackets because I don't know about this. So is the longest sentence always the most serious sentence? Because I guess there's an ambiguity of what does the most serious sentence mean? Because there was one point where we talked about the most serious sentence, and so I'm actually thinking maybe striking out, or I said most serious case. So imagine a situation, I guess, where we've got, I don't know, a level 3. It's more serious. But it didn't have, and let's say there's another case with that's a level 5, and for whatever reason, the level 5 actually has a longer underlying sentence. So the more serious case could have less. And so under those circumstances, which would be extremely rare, but it could happen, I think, do we want to go with the longest underlying sentence, or is it the longest possible? When we say longest possible underlying sentence, do we mean this is what the statute says could happen, or are we talking about the longest imposed underlying sentence?
I think you start saying possible, and there's going to be room for all sorts of liberty.
Can you just say the longest sentence will generally involve the most relevant risk and needs assessment, which in turn identifies the most appropriate services?
Okay, so I like that, and I actually want to go with that. But what I want to do is flesh out the possibility that we might have somebody with a potential statutory sentence in one case that is more than another, but that maybe there's a downward departure, and so the actual sentence is less, but the maximum statutory sentence is more. And so are we talking about the longest possible sentence, the longest possible statutory sentence, or are we talking about the longest imposed underlying sentence?
I think we're really getting into the weeds here. I think we just leave it as is, because for instance, Professor, what you just stated, right? If there's a departure, that case is likely going to community corrections already, right? And so that even if that's a lesser sentence, that case is going to go to community correction. I think we're really delving too deep into this issue. I think you leave it as you got it, or as the edits are, and that's the case. As the legislation goes through, those are specifics that can be worked out in legislation versus with our report. Just my thinking as well. I'm not meaning to override it all, but that's my thinking.
No, and I'm fine with that. I just, I can tell you from a lawyer's perspective, the legislation needs to address that, because a lawyer will jump all over that. I would. And of course I would argue it in whatever way, most benefits my client. But I think if we're talking, the longest imposed sentence versus the longest statutorily possible sentence, we're potentially talking about two different things. And so I do think somebody's going to have to flesh that out before it goes to the legislature, or at least in the legislature, it's going to have to be fleshed out.
I agree with Spence. I would leave it as is and let one of the legislators pick it up and start tuning it, I guess.
Okay.
Because with the departures, I mean, we all know, all of us on here are pretty current and frequent with our court systems in each jurisdictional district, and they vary. So, and as Hope put it, the term possibility, that just in and of itself opens it up anyway. So,
well, I think Hope is suggesting that we get rid of possible.
yeah.
Okay, so the subcommittee suggests that the case with the longest underlying incarceratory sentence should control which entity will supervise the sentences. The longest sentence, I'm going to say or most serious. I'm going to get rid of or most serious case, because I think that is not consistent. Will generally involve the most relevant risk and needs assessment. This in turn will identify the most appropriate services for a person under supervision. With that information, the entity best equipped to provide those services should be the entity that supervises the concurrent sentences. Jurisdiction for each case will remain with each sentencing court. And I put in something here, and Spence, I think you commented on this. I just wanted to toss this out and say, so I could imagine a situation where a district court would say, look, I'm transferring this and I'm willing to give jurisdiction over to, you know, whatever other county. And so do we want to create that possibility for a court to do that? Or are we saying no matter what, jurisdiction remains with the sentencing court? Okay, so Sheriff Carr is saying, I guess keep this highlighted sentence in there.
I like it.
I have a couple things, because this was recently opened up with Senate Bill 123 cases that they can be transferred jurisdictions if the courts agree. That said, I think one of the stakeholders you're going to hear from will be judges and attorneys on it. You know, so if you open that up, that's fine. But I do think you're going to hear stakeholders may disagree with that. And specifically, if there are victims or anything like that, you know, if you open that up, you have a lot of jurisdictional issues. But it is open currently, and so it's a possibility.
And so I think if it is open currently, then I think leaving this in would be consistent with it being open currently. It's number one, so it wouldn't be a departure. Number two, there might be logical reasons to transfer jurisdiction. So this would be permissive. It's not mandatory. And so it sounds like we're not totally in agreement on this, but I see value in doing this. Secretary Zamuda, Shelley, what are your thoughts on this?
It's fine with me, Professor.
Thank you.
Leave it in.
Okay, Shelley?
I agree.
Okay. Let's go ahead and unhighlight that. Okay, this will stay.
If you're going to leave it in, I think it needs to be worded different, unless the sentencing court and receiving jurisdiction agree to transfer, or somehow word it better than that. But I think there's got to be an agreement between both jurisdictions. It can't just be one court agreeing.
Okay, so unless the transferring court and receiving court. I was thinking it would just be the transferring sentencing court.
You're that way. I mean, but you know, you've got to look at it this way too. You're adding work to different courts
Gotcha.
that don't intend to have that work, and to different prosecutors, and that's why I think the agreement has to be made that it makes sense to transfer. And if we don't leave it that way, I think you're gonna have a lot of people raise issues with that down the road.
So maybe unless the sentencing courts specify their intent to.
I think you need to. There's only going to be one sentencing court, so it's got to be the original sentencing court and the other jurisdiction involved, or something like that. I'm not sure how to word craft that, but I really think that needs to be in there. Unless, again, I'm just one. If everybody else thinks I'm off my rocker, that's fine too. I just want to voice my opinion.
Well, I think you're right that there's only one sentencing court if we're looking at the second sentence only. But the nature of this is that we've got one person under two sentences, and so we've got two sentencing courts. Now, you know, there's always the possibility that the second one in time calls the ball. That could be unfair to the first one, and you're right, that's a resource issue. But that's why I think we could say unless the sentencing courts, or unless the courts with jurisdiction over each case specify their intent to transfer jurisdiction.
That sounds pretty good. That sounds pretty good.
Okay. It's the courts. jurisdiction over each case. Agree
On jurisdiction or transfer of jurisdiction.
to transfer jurisdiction. Okay, how about that? Unless the courts with jurisdiction over each case agree to transfer jurisdiction. Okay. Subcommittee proposes the following guidelines for consolidating supervision of multiple supervised people between district courts. Okay, this is just recap.
Can we change the word multiple supervised people? That almost to me sounds like several people versus dual supervised persons or people.
Got it. Yeah. Yeah.
Yeah. I'm John. As we're going through, I'm just tracking through with what my suggestions were.
Okay. Good. Thank you. Okay. Subcommittee proposes the following guidelines for consolidation of persons under multiple supervision. Now is the consolidating supervision of persons under okay. And this is so this first bullet point, embodies what we had in that paragraph there. I just want to be sure that we're consistent here. Longest underlying sentence, underlying incarceratory sentence. Is controlling. If a new sentence would place a person under supervision, on concurrent supervision, control of the case should be determined after considering these factors. Unless the severity of a new offense impacts the level of supervision, that part's actually okay. The defendant should be under the originating entity should maintain control. I'm not quite sure what we mean by originating entity. Would that be the entity already supervising the person? Is that what we mean? Or do people want to keep it with originating? I'm just having a little trouble picturing what that means.
To me, it means like, for example, offenders on community corrections, they're the originating entity, gets a new charge, is sentenced to court services. What it's saying here is community corrections maintains control of the case.
Okay.
Is that how you guys read it?
I mean, I assume that's the intent. As long as it's clear. Go ahead.
Okay, so about, I lost it. Okay, so unless the severity of a new offense impacts the level of supervision, the defendant should stay under the originating entity.
Okay, with severity of a new offense impacts level of supervision, the defendant
Should
should
stay
remain.
under.
Yeah, should remain under supervision of the originating entity.
Yes.
Yeah, good. Throughout the length. Throughout the length of the sentence. Okay, good. Thank you. That helped clear that up. That tightened that up. if the severity of, again, to stay consistent, we'll go with A. New offense requires a higher level of supervision. Control of the case should be given to the appropriate supervision entity and will remain in place through the end of the supervision sentence. Okay, is everybody okay with that one? So a question that I had on the next part, the language started shifting from my perception from supervising agencies to courts, and I'm not sure that that was the intent. Now, Spence, you had weighed in on that. So I had put in, so this said, if concurrent supervision cases have equal sentences, the courts involved must agree on a controlling sentence after consideration of these factors. So I guess the question is, is this intended for each court to go back and reconsider this, or is this a decision that gets made at the entity level?
Well, the sentencing should be, I would say it's going to be the judge. I mean, it's going to be at their level, up to the prosecutor to come up to an agreement on where it gets assigned. Yeah,
so for the sentences, I totally agree with that. But the question here is on the decision of who decides what the controlling case is.
The court always has jurisdiction. It's their probation. They're the ones that order the sentence.
Okay.
So I think, if the court, I don't know. I think you're trying, if you're going to tell a judge that the probation decides where that case goes, you're going to have some feedback.
Mm-hmm.
I know where you're going with this. And I agree, if there's two sentences, that are exactly the same, there's two burglary cases, one goes to court services and one goes to community corrections. It makes sense, if they need services, that it goes to community corrections. But I think having the agency decide that is a little bit stickier.
Okay, and I'm fine with that.
At the sentencing point, and I think that's what we're talking about, right? Maybe I'm reading too much into it.
I guess the question I have is this at the sentencing point, or is this, two sentences are in, now we got to decide who's going to supervise them?
Yeah. Yeah. So if I don't think we're talking about at sentencing, I think we're talking about after. I think it's back to the entities to determine who's going to do the supervision.
So,
to think I was about ready to agree with Spence.
Oh,
don't do that. Don't do that. No, I appreciate the clarification, and that helps me in my mind, that I agree as well. When I read that, that's not where my mind went.
Yeah.
Okay. Okay, so we'll say, and in fact, we'll say the supervision entities, just to clarify. Okay.
Rough.
Yeah, because this, indicates sentence has already been imposed, because if they have equal sentences, so court has already sentenced. So yeah, now it's up to the agencies to hash it out. At least that seems to be our recommendation. Plus, I think it will be easier for agencies to agree potentially than courts in neighboring judicial districts too. I mean, some might be happy to do it. Others might be like, no, I want to keep control of this myself, or no, I want you to take the whole thing. And I think there might be a little more requirement of cooperation among agencies. Okay, so these are the factors to consider: residency.
Sorry, I got a question. I'm having a hard time with the term controlling case. How about controlling plan?
So the reason I'm thinking controlling case, and this actually is a term that's used in court sometimes. So even when there are multiple cases within a district with different judges, judges and lawyers will refer to the more serious one as the controlling case. And that would typically be the case that I guess has generated the sentence that causes supervision to be with one agency rather than another.
I know what you're saying. I'm just looking for, I guess, more clarity here for explanation for people. It's
Sure. So,
oh, Shelley. I don't know what I can't explain it, but there's just something
Yeah.
about that sentence that
sure. So what's the language you're suggesting?
that's what I'm not sure. There's just something about that specific sentence that just raises more questions, and I don't know.
Must
can't
agree which sentence controls.
Which entity supervises the probations? Which entity supervises? I think it's just coming down to what entity supervises, right? So why don't we just say something like that?
It does, but one of the things we talked about was, yeah, you've got one case that, because we were referring to, you know, controlling case. We got case A and case B. Let's say case A is more serious than case B. That becomes the controlling case. That's the case that's kind of steering the ship. And we also talked about what happens if the supervision of the controlling case, which has caused supervision to be, say, with community corrections as opposed to court services, what happens when that expires before the less serious case?
I think I've got it. If concurrent supervision involves multiple cases with equal sentences,
Concurrent supervision
concurrent supervision involves multiple cases with equal sentences, the supervision entity involved or entities involved must agree on a controlling case after considering these factors.
Yeah, that works. That works. Good. Everybody agree on that?
Sorry.
No, I'm glad you did this and don't apologize.
It's good.
Oops, whoa, didn't mean to do it. Hang on. Okay, the ability of the person to travel to and from residence, place of employment, or school to the office of supervision authority, resources for residential, non-residential sanctions or rehabilitative treatment, supervision intensity, and resources available. What about that word, the supervision intensity?
Well, it's applicable when you know understanding the system and knowing the levels of court services as opposed to community corrections and parole. I mean, it is a term that's used.
Okay, if that's a term that's used, then I'm fine with that. Is everybody in agreement with those subparts? Okay, hearing no opposition. Financial obligations. So this was one where, you know, there was discussion about wanting us to address this.
Professor Francis, really quick.
Yeah.
What, on D, what about doing the level of supervision and resources available to the person on supervision? Is that a complete sentence?
No, but it's a bullet point, so I think it's
Okay. My bad. Okay.
So it's a factor. So no, it's not a complete sentence, but
Okay.
but I
If
like
you wanted
the
to
level
take
of,
out intensity, you could just say the level of supervision.
yeah. And resources available to the person on supervision by each supervising entity, just to state. Okay. Supervising entity enforces any financial obligations, including those imposed by a concurrent court according to these guidelines. Set a payment schedule consistent with ability to pay, apportion payments to concurrent courts. I proposed adding in and develop a plan for payment to be forwarded to each court that imposed a fine or fee. And here's what I'm thinking. So it sounds like one of the issues is if, let's say, Community Corrections has something from Shawnee County and Court Services has something from Douglas County, and supervision is being handled by Community Corrections. Instead of having the person pay money to, for fees or fines to two agencies, Community Corrections would collect everything in this instance and just see to it that somehow it gets forwarded to the proper court. Is that what we're talking about?
I'm going to lean to Spence, my PSI writer expert, on how that maybe should be worded.
Yeah, I think what we were talking about is just making sure each case is receiving money, right? Not necessarily who's collecting it. I mean, for collections, that's easy. Anything ordered by the court, there's a central payment center and it can all go through there. So it's not necessarily collecting the money. I think it's more making sure each case is receiving money, right? As in they're making payments towards restitution on 3 cases versus just 1 case, so that all parties involved are getting their money, if that makes sense.
Okay, so then does the language apportion payments to concurrent courts capture everything that's needed there?
Can we say something rather than concurrent court? Well, and maybe that's fine. I was just thinking to simplify it, payments for each case.
I do think it should be, that we should identify that it goes to the proper place. I'm not quite sure how to word that though.
Because your concurrent courts, I mean, it might be the exact same court, so it's not necessarily more than 1 court involved.
Right, but it might be different ones, and so this
it could be, but I'm just saying that's not necessarily always the case that it's going to be concurrent courts. We're going to have the same courts a lot of times.
Yeah. Okay. So apportion payments for each. Well, yeah, I guess maybe that would just cover it there. Should it be apportion and make arrangements for? Because apportion is basically just, this much to this and this much to this and this much to this. I think one of the concerns is, will people actually get, the fees and fines that they're supposed to, or will, different courts, different entities get that? So apportion and make arrangements for payment of, and Shelley, your chat just disappeared real quick.
She's got to leave.
Okay. Apportion and arrange for, or just leave it as a portion? I mean, I'm fine with leaving it as just a portion. Okay. Not hearing objections, I'm just going to leave it as a portion then. And then allow for 1 supervision fee only for the entity providing supervision. And I think that makes sense.
I'm going to throw in my 2 cents worth. I think that's fine for community corrections. If one community corrections transfers to another, and I'm not sure if parole has their own fee, but the supervision fees, for me, part of it is there's an accountability for each case, right? But the supervision fees are often ordered by the court, right? So if it goes to court services, they order those fees. There's nothing extra. And I wonder if that was the intent. So if a community corrections transfers to another community corrections, or if community corrections were to transfer a case to court services isn't going to collect any extra fees. I think that's the intent. But again, if you're specific with that language that there's one supervision fee, the supervision fees are often ordered by courts. And there's nothing that if the judge orders that, it's got to be collected.
Well, I think the idea behind this is that it's directing the court. You can only order, you can't double up on it.
Okay.
I think that's part of the intent.
Okay.
And yeah, judges may not like to be told what they can and can't do, but I do think that one of the things we talked about was not wanting to double up on fees and unnecessarily. And so I think this would be something that would apply to a sentencing court at the time of imposing sentence.
And just looking big picture, just an FYI, that could have a fiscal impact on courts. And I just throw that out there because I know that that'll come up eventually.
Yeah, I think you're right. I think it will. And I think that's something to hash out. But I do think that one of the things we talked about was we want to, reduce financial obligations where they're really not doing anything to further, the rehabilitative process or making somebody whole, and also for expenses that are actually realized. If only one entity is supervising, then both entities are not engaged in that expenditure. Okay, conditions of supervising. Okay, so we're still going with, well, here we're saying supervising court enforces all conditions of supervision. So here we are talking about supervising entity, right? We're not talking about the court doing it. The supervising entity will enforce all conditions of supervision established by one or more concurrent courts. Right? Because the entity is going to be the one that's enforcing the sentence. Or am I misreading this?
I see that as well. I mean, maybe Spence might see that a little differently, but I would say supervision entity, but I would also say concurrent court and maybe just say or board, since with parole or post-release, it's through the prisoner review board.
Looking at my edits, I had that. I took out court and agency, and I just put the supervising officer enforces all conditions of supervision for each case. That was my edit.
Actually like that.
Yeah,
all entities are considered officers, so I do like that.
Yeah.
See, look at us, Spence. We're getting along. We're agreeing with each other.
Spence, what page is that on? I like that language. I just want to lift that out of there.
It looks like page 4 at the top. And just for everybody's knowledge, I have a really good, I like Hope quite a bit, and I just joke when I say I don't agree with her, for those of you that don't know.
If she agrees with you much more, she's going to have to remove the KDOC from behind her name on the screen.
That's what we're hoping for. Did you find it, John? If you don't, it just says the supervising officer enforces all conditions of supervision for each case.
Got it.
Yeah.
And that was okay. So what did I do here? Well, one supervision fee. Is that right? So that's how we want it. The supervising officer enforces all conditions of supervision. Okay, good. Conditions of supervision, supervising. Oops, that's where we wanted to put it. I just put it in the wrong spot. I'm sorry. Back out of what I did here. Okay, so it's supervising. This is where it goes. Okay, that's right, right? Okay. Sanctions for violation of the conditions of supervision shall be imposed solely by the controlling court supervision entity. If supervision is revoked by the controlling case, all pertinent if supervision is revoked, all pertinent information shall be shared with corresponding courts and appropriate action. So this sentence confused me a little bit. I mean, maybe if the person under supervision is revoked due to violation of terms of the controlling case, all pertinent supervision shall be shared with corresponding courts and agencies for appropriate action to be taken.
I tend to oversimplify things, but could you just say if supervision is revoked, comma?
Mm-hmm.
Because either party can, it doesn't have to be by the controlling
right.
case.
You're right.
So if supervision is revoked, comma, all information shall be shared with the corresponding entity for appropriate action, because it would be the officer that takes it to the court or the PRB.
Right. Okay, I like it. There's an elegance in simplicity. Okay.
I don't know that I've ever been called elegant, but
there's a first time for everything. Termination of supervision. Supervising court of the controlling case determines when supervision will be terminated. So let's talk about this. Supervising court of the controlling case determines when supervision will be terminated. I think that's correct, but I'm not quite sure what we mean there. Are we talking about the entity goes to the court and says, can we terminate supervision, or, what's contemplated here?
Spence, I think this is going to need your wordsmithing, because for parole, it's just a sentence end date, right? Like there's no, you don't submit to an entity for closure. So it's just with the courts. So it would be the court. So I think he would need to do the wordsmithing on that one.
So, yeah, because I've thought about this one quite a bit. Again, it's the court's probation. They're the determining factor. I think the supervising entity can make recommendations for termination of supervision, but I don't think they're going to, the controlling case determines when supervision is terminated. That's I just don't think that's correct in the wording itself. So can it just say that the supervising officer can recommend termination of probation?
Well, I think that can happen anyway.
I almost wonder if we even need this section. I mean, because probation terms are set, and if we're sharing information as gathered, if there's meetings or whatnot, there's going to be discussions about possible early term, and there's, we've got some standards hopefully set up when people can be early terminated now, and this will just play into that. I don't know.
So I guess the first thing is, what do we mean? And are we saying, and I just made a quick change here, not because I'm committed to it, but just to kind of have a discussion point. Are we saying that the court that has jurisdiction over the controlling case decides when supervision ends? And,
ultimately, you're the judge and the prosecutor more likely sign off on those terminations. So to be technically correct, I think you're right with that. It's the jurisdiction. The officer, you can recommend it, but they're not the ones terminating the case.
Okay. So if everybody's comfortable with that change, let's go ahead and go with that. Spence, the next paragraph you had some comments on. Maybe a hard sell, two different branches of government, court and KDOC, that are entering the agreement.
My gut feeling, this is nothing super official. My gut feeling is that the court is going to have a hard time allowing, for instance, court services to supervise parolees. I think that's going that our court system is going to not just, when I say the courts, I mean the Supreme Court might have a hard time allowing that to happen. And that's just my feeling on this. Maybe they would come back and say, sure, we can make an agreement with that, but I just think that that's going to be a hard sell.
So on that hard sell, are you saying that there is some constitutional provision that would make illegal legislation that proposes doing that?
No, I'm not saying that at all. I just say you've got two different branches of government. So the easiest breakdown of it, the executive or wait a minute, now I'm confusing. I know judicial branch.
Executive.
And DOC falls under executive. So they're
right, judicial and executive.
So you've got two different branches of government when you look at the gist of it. And it's just my feelings is that I think that would be, the courts might not follow that and might be a stakeholder that disagrees with courts supervising, judicial branch employees supervising executive branch, not employees, but their parolees, post-release supervision.
Spence,
So I think,
don't know how to wordsmith that. Hope could do it, but that's my feeling.
So I guess the question here is, are we suggesting the legislature say, look, like it or not, you're doing it. This is the law. Or is it a situation where there would actually be a constitutional provision saying, no, what's executive is executive and what's judicial is judicial, and ne'er the twain shall meet, or you can't make them do it anyway?
I see it differently. I see the points differently, John. I see it as we can recommend this, but then you also have to get it passed. Legislation can do it, but you're going to have stakeholders that are going to be weighing in with all of this stuff, right? And I think that it's going to be that. I mean, we can make that recommendation, but I think that this part specifically is going to be a hard sell.
Now I see what you're saying.
I don't believe it would be a pass, but I'm just one individual.
Okay, so I just wanted to clarify, you're saying that you think this would be an impediment to this passing, not that it couldn't be implemented if it did pass.
Only this portion of it, nothing else. I mean, because we all know legislation will be worked and it's different parts will be pulled and fixed. But it's just my gut feeling.
Okay.
Spence, do you think that goes both ways? So you think that the courts would not want to supervise parolees? Would they have an equal problem with parole supervising a probationer?
Boy, that's getting even deeper into my non-specific knowledge. I really don't know. I guess just thinking of district court and my work with it, I'm not sure. It's hard. I could see that there could be judges that are going to be the Judges Association might say, yeah, we do not want parole officers supervising our district court people, but that I could be 1,000% wrong with that. I don't know. I just don't know. And if we want to leave this in here, that's fine. I just want to make us all aware that I think it'll be a hard part to get this through.
Yeah, and my suggestion is that the agreement is with KDOC and OJA and not, and because I think you can't do the different judicial district agreements.
Yeah,
It has to
that's a
be
good point.
I 100% agree.
Yeah.
Yes.
So it sounds like we should just get rid of this paragraph. Is that?
I don't think we should. I think we let that debate go out.
Yeah.
What I'm saying is that where you have Office of Judicial Administration in parentheses, I would put that
Yeah.
instead of the court.
Okay.
So, yeah, right after KDOC, yep.
I again agree with Hope. It's a win.
I'm gonna write all this down in my diary.
Me too.
Okay, so it's going to say Kansas Department of Corrections and okay, so this is the heading: Kansas Department of Correction and Concurrent Supervision, KDOC and OJA, Office of Judicial Administration.
Yep.
Yes.
Enter into an agreement whereby a person on parole or post-release supervision is simultaneously under supervision of the court shall be supervised exclusively by either KDOC or OJA. And in fact, I'm just going to say OJA instead of just a consistency and clarity. Okay. All right. Revocation. Supervising authority will provide notice and supervision, history documentation, blah, blah, blah. And this is, I think, in this particular context of the KDOC one. And so I think these two paragraphs were relatively uncontroversial. Termination, supervising entity will provide notice. Provide notice and supervision history documentation to the concurrent supervision entity. "30 days. 30 days prior to termination of supervision. So supervision of the person can transfer to OJA or prisoner review.
I think you leave it the court at this point.
Okay. Prior to supervision, responsibilities being transferred, the originating court is responsible for ensuring that the risk and needs assessment and all data in the case file is correct.
I think we should change court to supervision entity.
Yeah. Okay. Upon transfer of supervision, the receiving entity has responsibility for overseeing supervision conditions and updating risk and needs assessments of the case plan as indicated. Let's go ahead and do that. Okay. We'd had some discussions about, what happens when the more serious case ends before the less serious. Do we want to go into that, or do we want to just leave that out?
My thought was we really kind of addressed that up above, like with termination and that up above. And some of the other things could be potentially like, again, through DOC and OJA court services, it really could be an MOU kind of detail that we could ferret out the details of.
You know, I think you're right. I think that's more of an administrative thing that's better worked out at the agency level than here. Is there everybody in agreement on that? Hearing no objection. Develop consistent conditions of supervision for state district court cases.
I had just developed consistent conditions of supervision. I didn't know what the purpose for state district court cases would be.
I like that.
And then I also, as you move down through here, on A, I suggested maybe we make some change rather than saying all general conditions should be the same. Something about the recommendation should be the legislature adopt the recommendations of the Criminal Justice Reform Commission Conditions of Probation Subcommittee. State it something like that, because that committee has worked on standardizing conditions, and that basically alleviates A. So I think the recommendation would be just follow their recommendations.
Yep,
Yeah, I like that.
good idea.
Whoa, who said good idea?
I said it's a great idea. Great idea.
Okay,
If
so
I was in the same room, I'd be kicking him under the table, Spence.
I bet he's already got shin guards that he wears all the time.
I do.
okay, so what this is saying is the legislature should adopt the recommendations of the Criminal Justice Reform Commission Conditions of Probation Subcommittee as they have addressed this issue by creating statewide conditions of probation. Got it. Good. I like it too. Improve communication.
Professor, I don't think it's the condition of probation subcommittee, though. I think it's the standardized supervision.
Yes.
Subcommittee. Let me see what. Let me grab mine.
Standardized terms and conditions of supervision.
Yep. Yeah, that's it.
Okay. Legislature should adopt the recommendations of Criminal Justice Reform Commission standardized terms and conditions of supervision subcommittee as they have addressed this issue by creating statewide conditions of probation. Good. Okay. Improving communication. Okay. Information gathered by CSG indicates that there is inconsistent sharing of information between agencies across the state. Lack of consistent communication between agencies makes proper supervision of multiple supervised persons a challenge. In addition, information received by the subcommittee indicates that information about supervisees is not consistently shared with law enforcement officers. To facilitate better exchange of necessary and useful information, the subcommittee recommends Court Services, Community Corrections, and Parole develop recommended standards for communication. Spence, you had added in also, and I think correctly so, conditions of probation. So specialized assessments and I don't know why that did that. Conditions.
I think you could just make it a bullet point. Yeah.
Yeah, that's what it did that on its own. Or
Sure.
more correctly, I didn't do it properly. But yeah, I just wanted it to be a bullet point.
And this is kind of technical, but so the WRNA is WRNA. There's no A. There's no, yeah, that first A needs to go away.
Thank you. Okay, it is
What
gone.
about, you're not going to give the next one also?
Oh, yeah, sorry. I have LSCMI.
Let's see. MI. Thank you. Okay. And requirements of multidisciplinary team, supervision officer, treatment provider. Meetings should be scheduled by risk level. Prior to the meeting, list of supervisees to be discussed should be distributed to appropriate supervisors of officials. Monthly for high risk, bi-monthly for moderate risk, quarterly for low risk. Agency should outline expectation and process for sharing case management progress based on supervising entities. Policies and procedures, a condition probation progress reports, share information with law enforcement. Agencies should have access to databases of client information maintained by other supervisory entities. And in fact, entities. Supervising entities should have access to databases of client information maintained by other supervising entities. Is that accurate? That's pretty much what we agreed to, right? That they should have access, that the entities should have access to each other's databases. Okay, hearing no objection. Identify points of contact.
What if we, I am perfectly fine with the access to databases, but sometimes that includes a licensure fee to add more people. So if we just say should have access to client information maintained, and then we can figure out how to get that information to each other if it's cost prohibitive.
Yeah, I like that hope. Because I know as we move forward in Tyler's supervision, I believe, and don't quote me on this, and this, I know this is being recorded, but I think Tyler might have a function where maybe we can give read access at some point for certain information. And I imagine that that's exactly where you're going with this. So even if we're not able to specifically give data from our relevant systems, we should be able to provide reports or whatnot, or whatever information is needed to that other officer.
And or to like the portal, like it would, that language then would allow for if we develop a portal or, that type of thing.
Yeah, right. I agree.
Identify points of contact for dispute resolution with each entity to resolve disagreements between So I think we need to develop this idea more. This was in CSG's report, I think. I'm not quite sure what this means.
So this was my recommendation, and that just came from should something occur, let's just play this out, since we already established that court service and parole are difficult to work with each other. Just kidding. Let's say there was dual supervision and the court service officer and the parole officer, whoever had the supervision, but there was these MDTs and there was disagreement on how to move forward. There needs to be an entity like Spence and Hope are the designated dispute resolution contacts for those entities, right? Because that will the people that are involved in those cases will have conflicts, and who then works towards that resolution within those entities to resolve those.
Okay. So with that explanation, I think this sentence is okay. That identify points of contact for dispute resolution within each entity to resolve disagreements between entities. And I think we can leave that like that unless anybody wants to wordsmith that differently.
I was just going off of what Hope said, just for clarification's sake, so that it's easier to understand. Could you say identify points of contact for dispute resolution within KDOC and OJA? Because then that just, I think that keeps it at a high level, so it's not just the local officers that are going to be like, hey, this is, we'll decide this.
Well,
I
that's
think if
true,
you
because
specify it,
we would
yeah.
be the deciding factor for community corrections as well. Yep.
right.
Okay, good.
Okay.
Okay.
I think just for clarification's sake, I wonder if you do want to keep to resolve disagreements between supervision entities. Because otherwise that point doesn't make, I mean, just someone reading this outside of our group might
Okay.
not understand what
Got
that
it.
means.
Okay, so to resolve disagreements between supervision entities. Okay, so we'll hang on. Let me just get to this. Okay, to resolve disagreements between entities.
And I think you could take out the parentheses.
Yes, I agree. Okay. That's good. Okay, and actually, we already talked about this, I think. Well, no, we didn't. So there was still the issue of what happens when supervision is done and there's just fines and fees left. And we talked about, well, possibility to transfer it back to the residual, what I would refer to as the residual sentence, or keep supervision until it's done. Or do we even want to get into that at this level?
I don't know that it's needed, other than kind of my, what I read through there. And so my comment is just specifically about, is that good practice? Is that, that is the progression of supervision. So transferring a case or lower supervision is best practice. So it's not out, it wouldn't be out of the ordinary to transfer them.
Okay. I think there had been some discussion at one meeting, and I don't think you were there, so we didn't get your insight on this. I think there had been a question of, okay, on the one hand, continuity of supervision is desirable. That, if you're transferring people back and forth, that maybe isn't a good thing. But on the other hand, you don't necessarily want to have supervision at a more intensive supervisional level when it's not necessary anymore.
Right. You would do more harm than good by keeping them on a higher level of supervision for just fines and fees. The person under supervision could see that transfer as progression. If all I'm doing is being monitored for fines and fees. So that's my opinion on it. And that is not outside of best practice. If the continuity, if the supervision entity that is on a higher supervision level, let's say, so let's play this out, court service, community corrections, right? If all that's left is fines and fees, but that you want to keep them on community corrections for continuity, then it would be best practice then for community corrections to basically put them on an administrative caseload, to really not, if all you're doing is monitoring fines and fees, they shouldn't supervise them as they had done before. So,
and would that, if we say nothing here, would that happen? Would they probably be put on just an administrative caseload?
Yeah, they would follow our standards, so that would go. Yeah.
So it sounds like we don't need this paragraph then.
I don't think we do. Spence, do you?
I'm going to agree again. We do not need it.
Awesome. That's it.
John, actually, could we go back to the very beginning? I thought we would go back to my edits, and I just had really
Yeah.
only one of consequence.
Yeah.
In your first paragraph, you have CSG's information gathering included, among other things, conducting focus groups of chiefs. They did.
Yes.
I think that should be chief court services officers and community corrections directors, because I know they did do focus groups with those directors as well. So just to clarify that.
Thank you.
You're welcome.
Let me get to that. It is right. Groups of, was it right here?
Yes.
Chiefs. Yeah.
And just a wording thing, I have one more in that same paragraph.
Yeah, please.
Above that, after the paragraph of October 2021, you have, during these meetings, we received information and examined issues to be people being concurrently supervised by more than one supervision. That just seemed redundant to me, so I took out the word concurrently supervised or concurrently and just left it supervised more than one supervision officer.
Okay. Yeah.
And then just in the next couple paragraphs, you have reporting to multiple supervisors, and again, change to probation officers or supervision officers, and then you have a couple more agents there. But I know you're going to do work on that, so
Yeah.
it should be good.
Okay, let me just be sure about that one. So, which paragraph are you talking about with that? Just so I'll be looking for it.
Under problem solving, it says let's see. Duplication of supervision efforts extend unnecessary state resources, reporting to multiple supervisors.
Supervising officers.
You could either put supervising officers, probation officers, however we've worded it.
Okay. All right. And any place else?
The next paragraph, you have person reports to one supervising agent.
Yes, officer. Okay, got it.
And then we might have already corrected this one. Under the next paragraph, under recommendations, you have supervising, in the first sentence, supervising agent. Under recommendations, next paragraph down, supervising agent in the first paragraph.
Entity.
And I think everything else from my edits are good.
Okay, good. All right, what I will do is go ahead and clean this up, circulate it, hopefully by the end of today, actually. Take a look at it, send it out, or send it back to me, and you know, to not have a chain that becomes a problem. Just send your edits to me, and I'll integrate them with the idea that I guess Monday this gets submitted to Chairman Bennett. Is that correct, or do they go to Natalie?
I think, John, what I did last year, I think I submitted to both.
Okay.
And I don't think you can go wrong that way.
Yeah, I think that's a good point.
Good job putting that together, John. It looks great.
Well, thank you guys. I mean, you really cleared things up, and this is a long session today, but we got a lot done. So thank you very, very much. I really appreciate it. So I will go ahead and integrate stuff in, and we'll go ahead and circulate that, and hopefully everything will be good.
Awesome.
All right.
Thanks, guys.
Thank you all very much. I think we are
you.
done here. It's a wrap.
All right.
Thanks.
Bye-bye.
Bye.
Thanks a lot.